There's no use trying to a shark and I'm swimming. My heart still thumps as I bleed. I know your friends come sniffing, trying on my favorite shade. Need points, but you like me. Toe to toe, back to back, let's go. My love is very late. Jump
The sun's been out. Oh yeah, I've been out working, pulling weeds, stuff like that. But we've had sun for the last 2 or 3 days. I'm not a tanning bed guy.
No, I had these visions of you surfing and
Well, I used to do that
in the Bahamas.
when I was at UC Santa Cruz.
I remember you talking about that.
Yeah. Yep. But that hasn't happened for a while.
Well, maybe when you're in
Mauritius, yeah. Although in Rodrigo, the island next door to it, is where the young man was basically eaten by a shark here about a month ago. Kind of made the news.
We're going on Maui.
No, in the Indian Ocean on Rodrigo. Yeah. Yes, I know. Well, it's a good fear.
Testing.
One's empty, one's not moving on. One bird, one red.
All right, everyone, we're going to get started here in just a moment. So if you could grab your drinks and find a seat, that would be great. Welcome to the ADR Section's membership event, the third in our series this year. Today it's about client counseling. Oh, by the way, my name is Helen Ling. I'm the membership chair on the executive committee of the ADR Section. So today I'm going to ask Craig and Kathleen to give an intro of themselves. I'll just remind both of them to speak into the mic loud and clear so the people online can hear you. For those online, if you have any questions, feel free to type it in the comment section on YouTube. It will get read here in person so we can get those addressed as well. And if you have any questions here, we're trying to do it a little bit more casual, so feel free to ask them as they come up, and John will be happy to run the mic to you. So without further ado, we'll just get started.
Well, good evening. I'm happy to be here tonight. My name is Kathleen Royer, and my business is Northwest Family Mediation. And I come to mediation, I actually started mediating in 2000. That was part of my practice. I practiced family law for about 18 years, and then in 2010 started a mediation-only practice. So that's here in Seattle. So that's what I do.
You have set the bar very high in terms of keeping the introduction short. I appreciate that. My name's Craig Bellis, and I'm the chair-elect of the ADR section of the Washington State Bar. I've been an attorney for 40 years. I used to be an assistant attorney general, and I was a law professor full-time at Gonzaga for 8 years. I went back to school at Berkeley and got a degree in international law, and basically have been practicing international litigation, arbitration, mediation since then, and have been an arbitrator and a mediator since about 1987 or 85. And I teach ADR as well. I have taught in Europe, and I'm going to be teaching in the Indian Ocean, not in the ocean, but on an island in the Indian Ocean for 4 weeks, trying to help the citizens of Mauritius to develop a culture of ADR. Let me get started. There's a number of ways of looking at the whole issue of client counseling. The first issue, of course, is it's not just client counseling, it's client interviewing and client counseling. But some of you probably are aware of this, but you might be asking yourself, why is the ADR section talking about client counseling? Well, the simple reason is that client counseling is, in a fashion, a form of ADR. A lot of issues can be resolved, narrowed, walked away from, whatever the case may be, in the interview and the counseling session. So it is appropriate. And of course, client counseling is something that goes on throughout your entire relationship with your client and is very important in terms of preparation for litigation, arbitration, mediation. negotiation, whatever the case may be. The way I kind of look at this whole issue of client counseling is by starting and stepping back and looking at the macrocosmic issue. You can't really determine how you're going to engage in client interviewing and counseling unless you have a vision of what your role is as an attorney. And that vision of your role has evolved within the practice of law considerably over the last 30, 40 years since I started practicing. As you may know, initially the whole theory of client counseling was not really counseling, it was the authoritative theory. The lawyer runs the show, especially in the criminal law area. The lawyer runs the show, and the client walks in and is told kind of what to do after you get the basic facts. In the 80s, and actually the late 70s, the issue started changing somewhat to what's known as the client-centered theory of client counseling, more a Jungian approach. Maslow, Jung. I used to be a psych major and graduated from UC Santa Cruz with a degree in psychology. So the concept of I and thou, you're my equal, we'll work on this together, started to develop in the late 70s. And then that pendulum that went from authoritative all the way over to the client-centered has somewhat, I think to a large part, come back slightly to what commonly is referred today as collaborative client counseling, where there's a fair sharing of ideas and options and whatnot, and the attorney doesn't leave it, if you will, totally up to the client to sort of develop and decide all of their own issues without a little bit of leading. It's what in mediation we might call somewhat more directive or evaluative. At least it's got that element to collaborative. But it's interesting. Before I turn this back over to Kathleen, the thing that I find fascinating about this is my experience in law school and my experience as a law professor and my experience in teaching it up at Seattle U as an adjunct, to see the evolution of what's taught in law school. Obviously, we have much more in the way of clinics now. We have ADR courses, et cetera, et cetera. But in the substantive required courses, in most of them, you spend most of your time studying nothing but the results of pure litigation. You study case law. You study the appeals in order to learn the common law. You learn to spot the issues. But you don't learn a lot about the holistic approach to practicing law and assisting your clients. Your clients, and of course your clients is a broad category of clients, everything from a divorce, a dissolution potential client, to a multi-million-dollar contract, to a negotiation issue, to a criminal defense issue. Your client brings all sorts of issues into your office. And in order to be a good client counselor and interviewer, you've got to take more of a holistic approach to the practice of law than just spotting issues. I've sat in on various interviews where the client started spouting the narrative of what the issues were in their opinion, and the attorney would interrupt them constantly and go, well, that issue is that, and we can put that aside for now, and that issue is that, and we've got that resolved now, and da-da-da-da. And all the lawyer was doing was identifying issues. That's not a real transformative process for the client, and not a particularly satisfying one. And I'm guilty of it. I think about it. I taught torts and products liability as amongst my courses, and I'm thinking about the poor students who came in there, who probably were confronted with a mass tort situation they'd read about in the newspaper, or a bad automobile accident or something, and they go, "Oh my gosh, that's horrible. I mean, I can imagine if I was in that situation." And they come out of law school going, well, now there's contributory and comparative negligence, and maybe there's, an issue of this, that, and then what is the duty, da-da-da-da-da-da. And it's sort of dehumanizing. Law school has, to a certain degree, that thinking like a lawyer does not foster perhaps the kinds of things you really want to be doing as a lawyer. When a client walks in your office, has an issue, is asking for help, be it litigation or that kind of issue or a transactional issue, and your job is to listen and work with that client to try to figure out, what am I going to do? And in order to do that, you have to know all the tools in the toolbox. You got to know litigation, you got to know negotiation, you got to know mediation, arbitration, etc. So I'll stop there. Kathleen?
It's interesting that you talk about having taught torts. It makes me think about that family law is definitely, in many cases, the clients that you see who are family clients, their life is a train wreck at the moment you see them, but there are no damages to be assessed. And that's kind of the first thing you have to talk your clients off of is getting to the real issues and listening to them and getting to the underlying issues and the areas where the law does affect them, but recognize that there are many ways in which the law is kind of doesn't really apply to them for a lot of the issues that they have. I think a lot of what it takes to counsel your clients well is to know who you are as an advocate, to really look at that. And really look at what are you called to do. For most families, and I think that, as you were talking about the history of how client counseling has changed, I think if we look at the way family law has changed from the shift from fault divorce, which was a very, that puts it into this legal realm, right? You can apply legal principles to it and whatnot. But once we went to no fault divorce in the early 70s, I think that family law started trending away from a very legal approach and and shifted to a much more of a problem-solving approach. I think that's a really positive thing, quite frankly, because what families need is they need the tools to solve their own problems. That's my belief, and that's the work. That's how I do my work, is coming from that belief that if families have the tools they need to talk to one another, to work through their parenting issues and whatever else it is, then they can do that. And that you really do more damage than good if you keep trying to shove them into legal principles that are legal battles, rather, that really just pit them against one another. And particularly when they have to raise children, they still have to raise their children. So it's very important to think about who you want to be as an advocate. Oh, sorry. Anyway, and one of the things that I've been thinking about in terms of how do you start shaping your mind around that is, in King County, we do a lot of settlement conferences. So I work with couples who want to dissolve their marriages without using attorneys. And that's a little bit of a, there comes a point where attorneys are very helpful in mediation, and that's how I counsel my mediation clients, is I talk them through the process and say, listen, the place where the legal issues start popping up is the place where each of you has the right and probably should consider talking to an attorney so that you understand the implications of your negotiations. The idea is that you can come to whatever kind of an unconventional agreement you want to come to, but it should not be one that is uninformed. And part of that is, that you put the information on the table that you need for your property division, you get to valuation, you get to characterization, but that you also understand that that's where those legal implications start to arise. But that's kind of an aside. But what I was thinking is that's really about getting to problem solving. When you're in an adversary system, actually, I'm sorry, I kind of missed that point too, but I had this bigger notion that we have settlement conferences where attorneys and their clients are in separate rooms. That's a very common model for settling cases. Usually occurs late in the case. And the negotiations are court referenced. And from my perspective, that lends itself to a certain quality of problem solving, but it isn't as empowering a type of problem solving as when you simply keep the parties engaged in the issues and coming to resolution without the threat of, well, I'm just going to take this to trial, and I can get this at trial, and I can get that at trial. And it's like, right, but you have to do the trial. So let's talk about how do we really get to the underlying issues. And again, that comes, how you get there is by really listening to your clients and figuring out what's important to them.
Yeah, and how do you do that? Lawyers, some lawyers, have a tendency to be control freaks, might I say. Like to control the issue. They like their language. They like their culture. They like the culture of litigation. They like the culture of all the special words we have. But in order to find out what your clients, not only what their legal issues are, but what their interests are, what their goals are, the key is to try to draw that out of them and to work with them to come up with potential options and solutions. Now, I don't know how many of you took a client counseling course or competed in a client counseling competition, but most of the way that's taught today, and it really has evolved a lot has been written on this. As many of you know, there are entire books on client counseling. I think a few of them are sitting here next to me. There are recognized traditional stages of client counseling, and at the risk of boring you, I hope I'm not boring you, but the risk of going over those stages quickly, there's some interesting aspects to those. The typical recognized stages of client interview and counseling starts out with, they always say, with the icebreaker and the early greetings and introductions. Actually, they skip a step when they do that. You got to prepare for your client interview. If there's any way that you can get information, documents, some idea of what the problem is, who's involved, et cetera, especially if there's a conflict, you can short circuit the whole thing initially. But you want to do as much preparation as you can before the client ever walks in the door. But then you have the so-called ice-breaking or early greeting, the introduction situation. And, this varies, of course, depending on your client. You have some clients who, I used to have a construction company client who'd walk into my door and they didn't want to spend a second trading hellos. They wanted to get right down to it. But most clients on the first interview, you want to make them feel comfortable. My preference, I used to have a real nice big office where I had a separate coffee table and a couch and some chairs. My preference was always not to sit at the desk and have the desk separate me from the potential client. But I would engage in some initial hellos and whatnot, introduce myself. Depending on the individual, I might ask for them to introduce themselves first, and then I'd introduce myself. But you have to be careful. You have to, another issue is if you're a man and you have a woman walk into the office, you've got to be sensitive to that issue. There are cultural issues. If you're dealing with people from other countries, that you want to be in tune to. You want to have the classic, what's it called, Solon? I think I wrote it down here. I remember, solar. You want to sit square, open, leaning, eye contact, and relaxed.
All at the same time.
All at the same time, that's right. And talk and take notes and whatnot, and cross it, no. But the studies have actually demonstrated that physical posture puts the client more at ease. Because one of the very first things you're trying to do in this initial contact is you're trying to build trust and rapport. Well, actually, take it one at a time. You have to build rapport, which builds trust. And one of the things you definitely do not want to do is you don't want to be phony about it. You don't want to be mechanical about it. If you don't really care about this client, if you don't really care about the practice of law, if you don't really care about helping people, you're in the wrong profession. So you want to be sincere throughout. You want to truly be sincere. You don't want to fake sincerity because the client will pick up on it right away. And the client will not open up to you, will not give you the kind of facts that you want. If I'm saying anything that jogs something, jump in there.
Well, what it makes me realize is that, so much of it, I think, is that, again, it's what are you going to bring to the table? And everything that your clients are looking to you for leadership. And so they're, they're like, in that way, kind of like a child, that everything they see you doing is going to make an impression. And the best way you're going to get information from your client is not to have a preconceived notion of what you have to get from the client particularly, but really it is to just simply meet the client where they are and then figure out where do you have to take them. And that's really critical in family law. Sometimes clients come in and they'll start telling you their story, and that they kind of, acting like they maybe want to go after a person or whatever, and then before you know it, they're sobbing. And, you just have to be ready to ride whatever the ride's going to be. That's, you take your ticket every morning, when a new client comes in. But I think that if you're willing to just, kind of take that, I suppose taking that physical posture, I think that many of us probably just take that posture, we're just practiced at it, but it's that you have to be willing to just listen to your clients, because it's in simply listening to them and listening deeply that you actually can get to what's important to them. And that's really going to be critical to problem solving.
Absolutely. Let me just run through a couple more of the initial stages that typically are referenced. One is setting the agenda, letting the client know what it is, or the potential client, what it is you're going to be doing today. How we're going to, I want to hear your story, and we'll talk about fees later, unless you want to talk about them now, about confidentiality, those various things, and how we'll probably, at the end, we'll decide whether or not we're going to deal with each other, work with each other, or not. You want to kind of get a brief identification of what the type or nature of the problem is from the client. Again, you've hopefully talked at some point early on about confidentiality, to let the client know that they can speak freely with you. And again, something about fees. But the heart of the interview is the narrative, which Kathleen was just referencing. Mm-hmm. The client telling you the facts and circumstances, why that motivated their business. But your job is to do more than just gather facts. There are ways to effectively gather facts, but you want to do more than just gather facts. You're not there to cross-examine the client. Typically, the major problem most lawyers have with the narrative is they can't shut up. Lawyers want to jump in and start talking and organizing and identifying issues right away. Whereas if you start doing that, you may very well cut the client off immediately from very, very important information. Not only factual information, but emotional information, interest information that you really want to have in order to help the client out. You want to actively listen. You want to actively listen for not only the facts, but for the emotions that the individual has. You want to be empathetic. You don't want to just be a technician, okay? It's interesting, the things you find out when somebody comes in and starts talking to you. I have to tell a war story or two, but I had a client come in, very much nicer dressed than I ever was in the office. Walk into the office. This is when I was up on the 47th floor of what used to be the Columbia Center. And this client walked in, and he goes, and we had the little chat at the beginning, and he was very relaxed and everything, and I thought, oh, that's not easy. And we started to get into it, and I said, well, now, what brings you here today? And he goes, well, I'm the manager of a major bank branch over on the east side. And I go, oh, okay. And he goes, and I go, so what's the problem, or what's the issue? And he goes, well, I think I'm going to get sued by the bank. And I go, oh, really? And I go, why is that? And he goes, well, I lost some money. And I go, okay, so now this is evolving. And I go, so you lost some money. That's an interesting verb. Did you mislay it? Did you lose it? What did you do it? So he goes on and on and on. And to make a long story short, and it took a while for this all to evolve, he had been playing the options market with the bank's money on a Friday and putting it back into the bank on a Monday. And it had worked for years. He had actually made a lot of money, and the bank had not lost anything. But in November of 1987, the market went kaflooey, and he comes to my office, and he goes, I think I'm going to get sued because I've lost $500,000 of the bank's money? And I go, oh, okay. Do they know about it? And he goes, no, this is Monday. This is the day I'm supposed to put the money back into the, and I said, do you have any of the money? And he goes, oh, yeah, I've got about $250,000. And I go, where? He goes, oh, downstairs in the trunk of my car. I go, okay. So after we talk about this and I try to control my emotions and keep a poker face during this process, I start to let him know that the bank suing him is probably the least of his worries. I gently had to tell him, I had to prepare him for the fact that you probably will be spending some time in federal prison, which he did, and that's a whole other story. It's a very funny one, but I'm not going to take up the time here. The point being that these things can evolve. I had another client who was in King County Jail. He was a former student of mine. He calls me up. He's in King County Jail, and he goes, Professor, I'm in jail. And I go, oh. So I'm engaging in the interview over the phone. And I go, what's up? And he goes, oh, I got arrested for first-degree escape. And I go, first-degree escape? When did you escape? And he goes, well, I escaped 10 years ago from King County. I go, well, yeah, you were the student body president of the law school for the last 2 years. And you were just about to graduate. And he goes, yeah, they did, and I go, oh my gosh. So he starts to tell me about it. And I go, is there anything else I should know? And he goes, yeah, the Green River Task Force thinks I'm the Green River Killer. So, sometimes you draw these things, they come out slowly, and you have to be patient. And they say that after you let the client tell his narrative, you review and you clarify the client's narrative. That's verification. And that's kind of what I was doing there with those two interviews. You review and you discuss the goals, the interests, the values, the constraints, the pros and cons of the various options, and then you close typically by agreeing to the next steps, and who's going to do what. They always say it's a good idea to give the client some task, or have him or her agree on some task. But that's kind of a rough outline of your classic, just the mechanical stages of what's considered a good interview. We can digress into various aspects of that, but I'll leave that up to Kathleen. If you have,
I don't know. Do we have any questions any questions at this point? No questions? No?
It seems like the broader statement may not be so applicable to family law in King County, where you have the range of possible outcomes. So sometimes if I have a client especially who has expressed concern about the total amount of fees, I'm going to try to be a little more directive to alert them to the way it works in King County and try to get their focus on that, as opposed to fault, which sometimes still comes into play in family law in the client's mind.
In terms of, so is that a question or it's a statement?
Or it's making an observation that
Okay.
in family law, it's sometimes not as broad. Your counseling can't be as broad. So, but I might get your feedback on it. Do you have the same impression, or do you let them go on for a bit before you let them know that they're in left field?
Well, it's interesting. I think that I tend to, I haven't been doing client counseling in terms of, client intakes, except in the context of mediation. And so, that's a whole nother area to talk about is, in that context, how do you help your client focus and counsel them about that in the context of trying to problem solve, right? That's a sort of different question. I think in family law, one of the things that is, and I think it's probably true in most areas of law, but it's very hard in family law that people always want to jump to the end game without getting to the underlying stuff first. And you see that, for example, in property and asset or property and liability distributions. Everybody wants to start dividing up everything and staking turf because that's the urgency speaking, right? That they want to know what's going to happen next, what's going to, what's my life going to be like, without thinking that really if you kind of walk through to say, okay, what have we got here? How's it valued? How's it characterized? What are some options for moving it around to make it work? Then you come up with a different answer. And it's in creating that process that you also diffuse that anxiety. So one of the things that, that's a big part of dealing with clients when they come in the door and meeting them where they are is figuring out what are their anxiety trigger points and how do you talk them off that ledge? Because that's really the only way you're going to get them to a place where they can actively problem solve, and they have to take that over. So.
Yeah, I had the experience early on when I was in my second, third year of law school. I worked for legal services, and I didn't have any training in client interviewing at the time. And I remember one of the issues that constantly came up was, I always wanted to do something for my client, but I didn't have the context. I didn't know what the results were. The classic example that people give is, I think some educators give, is a situation where somebody walks into your office and says, I'm represented by this criminal defense attorney and he keeps charging me this $500 processing fee or something like that every time I walk, or facilitation fee to talk with the prosecutor. It makes me a little nervous that I'm getting charged this fee all the time. Okay, you're another attorney who he's come to consult about this rather, sounds like, sketchy behavior on the part of the other attorney. So what the attorney does is goes, oh, okay, what we need to do is you need to go in there with a tape recorder, and you need to tape record this the next time he says that, okay? So that's the advice the second attorney's giving. He thinks it's, I'm giving this person a task, I've identified the issue, now we need the proof, all right? Well, the individual goes and he gets the tape, he brings it back, and now the attorney's confronted with this tape and he's thinking, what am I going to do with this tape? Not to mention the fact that the taping was illegal and a misdemeanor in the state of Washington in the first place. And so, the thing oftentimes you have to do for your clients is you have to really look at all of the options and possibilities. You got to put them in context. You got to come up with a plan that makes some sense. If you don't know what the law is, but you still feel familiar enough with the subject matter that you're willing to take on the representation, you got to tell the client, I need to do some research on this. That's my job. First thing I've got to do is I've got to figure out how this all fits together before we can come up with a plan. I don't have my ego so involved in this representation that I'm going to just give you something to show that I'm the smart lawyer. I remember I used to teach with another law professor who oftentimes used to tell his students, never admit you're wrong. And I used to tell my students, always admit you're wrong when you're wrong. Honesty is always going to be the best policy in your relationship. You're going to develop integrity, you're going to develop trust. People are going to learn that you're a human being. You can't know all of the answers. So I digress.
Well, I think that, I think it's important to think about, again, I believe, and maybe it's just because it's the nature of the practice that I've had, that, again, it really comes back to, can you actually, can you let go of, I like the fact that you brought up this notion of ego, because, your ego, for you to really represent your client's interests, your ego can't be on the line, I don't think. I think you have to let your ego go. It isn't about you. It's not your case. It's your client's mess, right? Your client is the one who, however they wound up in whatever it is they're in, they got themselves there. And what they need is some leadership to get out. And really good leadership is planting ideas that other people take on as their own, right? And that's that, that's that highly collaborative client work, I think. But at the end of the day, I think that we're in a market that is changing very rapidly, and it's been changing for a number of years. But it's particularly changing because people have so much access to legal information on the internet, and they can file their own legal documents, and they can do a lot of the stuff that attorneys used to do and used to control. And as attorneys, and as people have taken more control of it, it's diluted this whole sense that people have about the urgency of actually getting legal advice. And so the downside of that is that it really is impeding access to justice because people think they can just make their own justice. And so they don't really have, they only have this veneer of, this sort of veneer of legal ability. They don't really have the opportunity to get to actually what could be some real legal issues, right? They think, oh, I can just do it all myself. I'll do it on the internet. I'll fill out the forms. I'll file them, and, done and finished. And then when they go to enforce a decree that they've entered, they can find themselves sometimes in a complete mess. So it's really about how do we as attorneys meet our clients in that environment and help them understand what value we really do bring to the table in coaching them and in helping them really define what are the legal issues you have to be paying attention to, and what are the other things that are really just about problem solving.
You bring up an interesting point. I'm almost embarrassed about it for our profession. Classic situation today is when you're ill, you get on the internet and you diagnose yourself. And doctors love it when you go in there and you tell them what it is that is wrong with you and what you need in the way of a prescription and whatnot. Well, the same kind of thing it happens in the legal profession. Individuals come in. In the old days, what people did was they would go to 5 different lawyers, and then they'd change their story to fit the situation. So on the 5th lawyer, so that they had a case. They didn't have a case on the 1st, 2nd, 3rd, or 4th, but now they have a case. That happens, still happens today. But now people a lot of times will do research. But the part I'm embarrassed about is the medical profession actually got ahead of the power curve before lawyers did. The medical profession started teaching in medical school that you're not God, okay, doctor. These people, this is their body, this is their future, this is their health. You've got to collaborate with them in order to come up with a resolution that not only is medically and physically appropriate, but is psychologically and emotionally appropriate for these individuals. Lawyers, like I say, have been sort of catching up with the collaborative aspects of dispute resolution, client counseling, etc. The recognition, the I-thou, the not I-it, I-thou. You're both human beings. You, the lawyer, the client. You are not necessarily the captain, authoritative captain of the ship, but you certainly have skills that the client doesn't have. So you gotta catch that balance between letting the client, decide, or with you decide what's the best way to go, what are the issues, and at the same time, as you point out, guide the client with the special knowledge that you have. And this is true of the entire relationship. I might add, we have some really experienced mediators and counselors in the audience. I don't know if they wanted to add anything. You don't have to ask a question if there's any.
Feel free to weigh in.
Yeah, if there's anything that's been said that you agree with or vehemently disagree with or want to expand on, don't hesitate.
Yeah, it's open mic night. No?
No? Yes? No?
Well, I just have a comment about the collaborativeness, but there's also a role that as professionals that we play for our clients, which is to take some of the weight of the world off of their shoulders. And I remember, with my very first client, I knew that I was a real lawyer when she came in looking troubled and stressed and walked out of my office feeling like, okay, I've got somebody who's on my side who's going to help take care of this. And she felt better and I felt stressed. I mean, it was like, that was part of my job, like, I'm here for you. It's almost like being a parent where you're collaborating and you're listening, but you're also taking, and I think we expect our doctors to do the same thing. You know, okay, I am taking this problem and I'm putting it in your hands, and I am trusting you with it.
You know, it's interesting that you talk about taking the weight of the world off your clients, and I would say a consideration in that might be that really, do we see our role as taking their stress over and making it our own? Because, you know, that leads to ulcers and way too much drinking. But I think that what the reason that family law mediation is so important is because it's really about empowering people who feel powerless, right? When our clients come to us, they don't feel powerful. And they may be people who have felt really powerful in their lives, but they're in a circumstance where they're powerless. And really, it's about, you know, it's in some ways, it's almost kind of like that martial art notion of that you bring the force to you and through you. And that's where we can show really good leadership for our clients. Not by kicking the can down the road, but by truly helping them solve the problem. And, you know, I have this notion about how, you know, I made some notes today about how, you know, when we're in an adversarial system, you know, we marshal evidence and we take positions and we just go get a remedy. And, you know, that's okay in certain circumstances, but that model doesn't really fit for most people. And it doesn't fit for families very well at all, except the most high conflict, irascible, you know, intransigent of them. So and that's a process that guides a kind of mindset, right? And it does not guide a mindset of empowerment in any shape, because you've given away decision making, right? And so that's where you have to kind of see, where does your client fit on that spectrum? And by contrast, when you look at engaging in mediation, it's a problem-solving process, right? You exchange information, you explore options, right? And then you develop an outcome that works. And that's a very different mindset and a very different way that people walk away from that.
I agree 100% with that. And you made a number of very interesting points. It jogged a number of things. And I think you recognize one of them. It's wonderful if you can take that weight off of your client's shoulders, but you don't want to be the sponge that absorbs all that pain. You know, you have to maintain that. And that's the great thing about being more collaborative, that the client remains invested. True, they now have a partner to help them out and to guide them, but they haven't just dumped it on you. And it's true of many different fields. I mean, I have, you know, these big corporations. They'd love for me to just take it over and, you know, tell me what happens with it sort of later. Or a criminal defense attorney when I used to do that. But in all those instances, those people are, I think, better off, and I'm better off. I'm much more comfortable. I'm much less likely to have a heart attack if I get them to work with me. You set that role initially. The other thing about roles is very important. Clients typically respond to lawyers better if you fulfill at least some of their initial role expectations. And this was true when I was a law professor. When I started out, I used to walk into class with a Pendleton and blue jeans because I was comfortable. I thought the class should enjoy what they were doing, but the students wouldn't take you as seriously. As much as they liked the idea of me being an equal or whatever the case may be, they much preferred me to be in a three-piece suit or a sport jacket or whatever. And I learned early on that I could guide and direct easier if I met their initial expectations. And I found that true in client counseling and representing clients as well. One, I pay them respect by getting dressed up for them. It depends on your client, but you know, I have software clients that they don't care what I look like. But you pay them respect. They know that they have a real lawyer, and then they will follow your lead easier. So the role theory that's involved is, I think, significant.
You know, I had this, in working with families, it just made me think about taking the weight, helping them take the weight off. And I used to have this great thing that I would do with clients that, you know, in family law, clients really just want to engage and engage and engage, and they just can't stop themselves. And, you know, and so whenever I would have the client who really just was like, I can't deal with, you know, what he's doing right now, and he's always doing this and he's always doing that. And I said, why don't you just hold a different image of him in your mind? You know, so imagine that, you know, so it's like the husband who's saying, well, you have to do this and you have to do that and you have to do this and we've got to do, and always on the control thing. So can you just hold this image in your mind of all you're doing is standing there with your hand on the forehead? And he's swinging his arms, he's jumping up and down, he's doing whatever he's doing, and all the energy you have to expend to engage with him is just hold your arm out. And all you do is sort of lift your hand and check to see, is he still doing that? Okay, he's still doing it. All right, never mind. And I'll check in again. And I said, just really try holding that image and letting him do whatever he's going to do, because you can't control it. Just let him, you know, or her, whichever, you know, let him just move. You know, doesn't matter. All you have to do is just stand there, check in. And the clients that I did that with, you know, as their case was winding down, more often than not would say, man, that saved me. Because it helps them reframe it. It helps them, again, it's meeting them where they are and giving them tools so that they can find a path and find their own path and find their own grounded path.
You jogged another thing in my head with regard, and it might be an appropriate way to sort of wind down the discussion. It's at the end of an interview with a client initially, and you say, no, I don't think I should represent you. There was a time, again, where you didn't have that option. I mean, you did, but it was frowned upon by the Bar Association and whatnot, and by the courts. If a client walked into your office, you were like a free clinic, not a free clinic, but you were a clinic, and you had to take the individual's case 9 times out of 10. Today, although today a lot of times you don't have the luxury because you can't afford to say no, but ideally today, after going through the interview, and there's been a lot written on this as well, if you personally cannot represent that individual because you don't feel like you can do a good job because you disagree with them so thoroughly, or you just don't feel that it's a good fit, you can't rationalize the position you're taking. See, again, 40 years ago, you could always say, this is an adversary system. I believe in the system, so therefore I can represent anybody, and truth will out. Okay, it'll rise like a phoenix out of the ashes. And I'm performing my function as a lawyer, and I believe in this role. Today, there's a fairly large movement that says you shouldn't do that. Everybody's entitled to representation, especially criminal defendants, but everybody's entitled to a lawyer, but it may not be you. One other little quick war story. Big construction company comes into my office, tells me about how they messed somebody up and they didn't pour the concrete right, and they had a continuous pour and it stopped halfway and it didn't meet the specs, and they were in big trouble with the owner and this, that, and the next thing. And I'm thinking, okay, I'm listening, and I'm thinking, all right, well then maybe we should prepare for negotiating with this. And they go, negotiating? No, we're not going to negotiate. And I go, well, what are we going to do? They go, we're going to sue them. And I'm going, we're going to sue them? And I go, well, how are we going to do that? He goes, well, that's the way we do it. We always take a preemptive strike. And I said, I can't think of a theory to sue them. And I said, I'm sorry, I can't in good faith represent you. And you try to do that without being, you're an idiot and I think you're unethical and all that sort of stuff. But he go, no, I don't think I can do that. I can't, in good faith, figure out a way to bring this lawsuit. I can refer you to some other lawyers you might want to talk to. But, I just today, after an interview and after you get the facts, you may very well come to the conclusion that I don't need the heartache. I don't believe in the cause. I'm an advocate, Obviously, when you represent somebody accused of murder, you don't believe in murder, okay? But you believe that the individual has arguments and is entitled to. But if you get to a point where you can't do that at all, you're better off bowing out.
I think that's and so the point is not can you not afford to say, what was it you said, you can't afford to say no, it's can you actually afford to say yes? Because that becomes that's a different question when you take that case that is a nightmare that then ends up in a bar complaint, in a malpractice suit, because you've taken that high conflict client that doesn't listen to anybody and is just going to be looking for another, anybody, just get in line if you want to be the next victim. I think it's really important to, again, it comes back to knowing who you are as an advocate and how do you want to work. I had a guy, so this is my worst story. I had a guy who came in for the client interview, and he marched in and he puts his file down in front of me and he says, I want an attorney who's a warrior, and I want you to make the other side miserable, and I want you to do la la la, and he rattles off a whole bunch of things. And I sat there very politely listening to him, and I said, well, he said, and I want you to win for me. And I said, well, all those things that you've described are really not those are not ways that I win my cases. So I'm afraid that I may not be able to work with you unless you'd like to know how I actually win my cases. And he's like, well, okay, how do you do it? And I said, well, first I get all the information that I can about the other side to know what their position is first. And then I get all the information, I just went on and I said, and this is how I work. And if that's what you'd like to do, then I think we can work together. But, you're free to call it because you're participating in that client relationship.
Anything else? Helen, any questions? Okay. Yes.
I just had one other comment that kind of builds on that, to the caution about buying into the client who comes into your office and relating too much to the story that they come in and tell, because it's very preliminary information, and so you're sitting there going, oh yeah, that other side, oh, they're really a jerk, and oh man, they've really done you wrong, and oh yes, we're really gonna go after them, and all those kinds of things when somebody's just walked into your office. So it's, and that can end up in buying in something that you're going to may well have to back away from later as you get that more information you talked about, Kathleen. And so that's something, a mistake you don't want to make in the first interview. But you do want to reflect that their emotions about, yes, that must be causing you a lot of anxiety. That's a very difficult situation that you're dealing with. That must be incredibly hard. Those kinds of things, reflecting the emotions. So you're reflecting instead of buying in, because so many people think that they're creating the rapport when they buy in.
Yeah.
No, you're creating the rapport when you give the empathy by reflecting what it is that you're hearing.
And it's in that reflection that's going to get them to the real story.
Yeah, no, absolutely. And that mirroring, that reflecting of not only the facts, so you get the facts straight, but but depending on the case, a lot of times the emotion. And that'll occur, as you know, in a family law case. It'll occur in a personal injury case. It'll occur in a contract dispute where you've demonized the other side. You're right. It's the old expression, God save me from a client who knows they're right. Because, you and your client are oftentimes shocked the first time you walk into like a mediation, you hear the other side. It's like, holy cow. That's a pretty good argument.
In the context of counseling a client for family law mediation, I have found it essential to have them understand that it is an opportunity for them to resolve the case within the range their way, make sure they understand what the range is, and also understand that there are no assurances as to what the decision maker in the case may do. And we've all heard it. I'm sure it's a big joke. No family law attorney in King County would ever say that with, 50-something judges on the bench, you can get 50-something different opinions on the same set of facts. The client has to accept that we aren't going to be able to control it except in the context of settlement, of mediation. And beyond that, we think it's going to be in the range. But until they accept that, that anxiety will continue.
That is, that's the same issue you have with brand new law students. Just, why are we reading these cases? There's the law, there's the facts, and there's the answer, And you have to educate your clients that ain't the way it works. So. With that, anything else?
No, I don't think so.
Thank you very,
Thank
very
you.
much. And I'd encourage anybody who's listening in out there who is not a member of the ADR section to please join up to get the benefits of such.
I do have one more thing. I brought a couple of resources with me. And I don't know if I just have found these kind of useful. One book is called, if this is for law students or new attorneys who have not read it, this great book by the Harvard Negotiation Project called Difficult Conversations. It's a kind of, it seems kind of like a pop psychology book, but it's got a lot of really great tools in it. And another book that I've been reading is The New Lawyer by Julie McFarland. And it's a really interesting perspective on how the role, and it's called The New Lawyer, how settlement is changing the practice of law. I think it's a very forward-looking piece of writing, and I think that if for all new lawyers, newly minted or soon to be newly minted lawyers, if you don't have a copy of this book, you should get it.
Thank you.
Thank you so much to both of you. Here's just a little thank you gift for each of you. And thank you so much for coming, and thanks for those online who are participating. I want to remind you that the last installment of our membership event series is happening September 16th. And that will also be the date of our annual membership meeting. So if you're a section member, that's the time to come, and you get to vote on the slate of new officers and executive committee. So it's an exciting time. We'll be doing most likely a topic on ethics. So it will be very interesting. So thanks so much. And for those here,
Will that be CLE? Will that have a
good question. The question was, will the ethics panel be a CLE? We will most likely be seeking CLE credit for that. So we probably will be doing CLE.
People are always looking for ethics
Yes.
credit.
So it'll be a big push. Come and get your ethics CLE credit. For those here, please feel free to stay and enjoy the hors d'oeuvres that are in the back. And if you haven't, grab a drink. Thanks so much.
Thanks.